Good day, Britain. You know the European Court of Human Rights has completely lost the plot when they are demanding the UK justify why we won't let a woman who voluntarily travelled to join ISIS, married a terrorist fighter, and spent years in the Islamic State come back to Britain like she's just been on an extended gap year. Home Secretary Shabana Mahmood has vowed to challenge European judges to prevent Shamima Begum from returning to the UK, setting up what could be a landmark legal battle over sovereignty, national security, and whether Britain gets to decide who hold British citizenship or whether unelected judges in Strasbourg call the shots. The ECHR has demanded answers from the UK over the decision to revoke Begum's citizenship after she left East London aged 15 to travel to ISIS-controlled territory, and they are asking whether stripping her citizenship violated her rights under Article 4, the prohibition of slavery and forced labour, essentially treating her time with ISIS as trafficking rather than voluntary participation in a terrorist organisation. This is a story of how human rights law has become so warped that it's being used to argue terrorists should be welcomed home, while the Conservatives are warning this case demonstrates everything wrong with the ECHR, and how Mahmood's willingness to fight this could define whether Britain can actually control its own borders and citizenship decisions, or whether we're permanently bound by European court rulings that prioritise individual rights over national security. Quick favour before we explore this legal and political minefield. If you're sick of unelected European judges trying to force Britain to accept terrorists back onto our streets, hit that subscribe button right now. Over 94% of you watching haven't subscribed yet. It's completely free, takes a second, and helps us keep exposing how human rights law has been twisted to protect the rights of those who destroy our society. Smash that notification bell so you never miss when we document the next ECHR overreach or sovereignty battle. If you've just subscribed, you're brilliant. Cheers! Now, let's dissect why this case matters so much. Let's start with the basic facts because they are crucial for understanding why this case is so controversial. Shamima Begum left the UK from East London aged 15 in February 2015, travelling to ISIS-controlled territory in Syria. She wasn't kidnapped. She wasn't forced. She voluntarily travelled alongside two school friends to join the Islamic State. Upon arriving, she married Dutch Islamic convert Jago Redijk, an ISIS fighter, and had 3 children with him, all of whom died in infancy. She spent years living under ISIS rule, supporting the caliphate. Then, after ISIS collapsed and she ended up in a Syrian refugee camp, she wanted to come home, claiming she made a mistake and deserved a second chance. In February 2019, then Home Secretary Sajid Javid revoked her British citizenship on grounds of national security, arguing she posed a threat to the UK. The decision was based on her eligibility to claim Bangladesh's citizenship through a parent, meaning she wouldn't become stateless, which would violate international law. Begum challenged this decision through UK courts, ultimately losing at the Supreme Court level, which upheld the government's right to strip her citizenship. That should have been the end of it. The UK's highest court ruled the decision lawful. But now the European Court of Human Rights is getting involved, and that's where things get really problematic. The ECHR document published last month states Begum is challenging the citizenship revocation under Article 4 of the European Convention on Human Rights, specifically the prohibition of slavery and forced labor. Think about what that means. She's arguing that joining ISIS, marrying a terrorist fighter, and living in the caliphate should be treated as trafficking or slavery rather than as voluntary participation in a terrorist organization. Her lawyers are framing her as a victim rather than a willing participant, claiming she was lured, encouraged, and deceived for the purposes of sexual exploitation, and that she was given, as a child, to an ISIL fighter to propagate children for the Islamic State. This framing is crucial and deeply controversial. Gareth Peirce, her lawyer, argues it is impossible to dispute that a 15-year-old British child was in 2015 lured, encouraged, and deceived for the purposes of sexual exploitation to leave home and travel to ISIL-controlled territory for the known purpose of being given, as a child, to an ISIL fighter to propagate children for the Islamic State. That's painting her as a trafficking victim, a child who was groomed and exploited, with no agency or responsibility for her decisions. The lawyer also criticizes a catalogue of failures to protect a child known for weeks beforehand to be at high risk when a close friend had disappeared to Syria in an identical way and via an identical route. Now, there's some complexity here that deserves acknowledgement. Begum was 15 when she traveled. That's a child by legal standards. There are legitimate questions about grooming, radicalization, and whether a 15-year-old can truly consent to joining a terrorist organization. Her lawyers argue UK authorities knew she was at risk, knew her friend had already traveled to Syria, and failed to prevent her departure. If authorities had information suggesting she was being groomed for radicalization and did nothing, that a failure of safeguarding that should be examined. However, and this is crucial, acknowledging she was young doesn't mean treating her as having no responsibility whatsoever or requiring Britain to welcome her back. Plenty of 15-year-olds face similar grooming attempts and didn't travel to join ISIS. She made choices, even if influenced by propaganda and poor judgment. She stayed with ISIS for years. She married a fighter. She had children there. She lived under and supported a regime that committed genocide, mass rape, slavery, and countless atrocities. And multiple interviews she's given from the refugee camp have shown remarkably little remorse or understanding of why people might not want her back. Shabana Mahmood's vow to robustly defend the decision to revoke Shamima Begum's citizenship is exactly right. A government source stated, "The Home Secretary will robustly defend the decision to revoke Shamima Begum's citizenship, which has been tested and upheld time and again in our domestic courts. The Home Secretary will always put this country's national security first." That's the correct priority. National security must come first. The UK Supreme Court already ruled this decision lawful. British courts, applying British law, concluded the citizenship revocation was justified. Why should European judges in Strasbourg be able to overrule that? Shadow Home Secretary Crisfield's position for the Conservatives is even more emphatic. She has no place in the UK, and our own Supreme Court found that depriving her of citizenship was lawful. It is deeply concerning the European Court of Human Rights is now looking at using the ECHR to make the UK take her back. This gets to the fundamental sovereignty question. Should Britain be able to decide who holds British citizenship and who poses enough of a security threat to warrant citizenship revocation? Or are those decisions ultimately subject to review and potential reversal by European judges applying European human rights law? The Conservatives argue Begum should not be allowed back under any circumstances. That's a clear, unequivocal position that reflects majority public opinion. Polling consistently shows overwhelming opposition to Begum's return. The British public doesn't want her back. They don't trust that she's been de-radicalized. They don't believe 15 years ago excuses 4 years of actively supporting ISIS. They worry about the security threat she poses and the message it sends if Britain welcomes back ISIS brides who voluntarily joined a terrorist organization. The 4 questions being posed by Strasbourg judges are revealing. They are asking whether the Home Secretary had a positive obligation under Article 4 to consider whether Begum had been a victim of trafficking before stripping her citizenship. This fundamentally reframes the entire case. Instead of asking whether Britain has a right to revoke citizenship of someone who joined a terrorist organization, the ECHR is asking whether UK authorities failed in their duty to protect a trafficking victim. That shifts the entire legal and moral framework. Bernberg per solicitors, representing Begum, claims the court's communication presents an unprecedented opportunity to address significant considerations raised in her case and ignored, sidestepped, or violated up to now by previous UK administrations. They are positioning this as Britain finally being forced to confront uncomfortable truths about safeguarding failures and trafficking. But that's a deeply one-sided framing that treats Begum purely as victim rather than as someone who made choices that resulted in her supporting a genocidal terrorist organization. The reality is more complicated than either extreme portrayal. Yes, she was 15. Yes, there were likely grooming and radicalization factors. Yes, UK authorities could have done more to prevent her travel. All of that can be true whilst also acknowledging that she voluntarily joined ISIS, lived there for years, showed little genuine remorse, and poses a potential security threat. The question isn't whether she was young and potentially groomed. The question is whether that history requires Britain to accept her back despite national security concerns and Supreme Court rulings upholding citizenship revocation. This case has massive implications beyond just Shamima Begum. If the ECHR rules that Article 4 requires Britain to consider trafficking frameworks before revoking citizenship of ISIS members, that potentially applies to other similar cases. It could make citizenship revocation much harder, requiring extensive investigation into whether someone was trafficked or groomed before any action can be taken. It could prioritise individual rights over collective security in ways that make Britain more vulnerable to terrorism. The case also feeds directly into the ongoing debate about ECHR membership. Both Conservatives and Reform UK argue Britain should leave a convention, viewing it as an obstacle to effective immigration control and security policy. Cases like Begum's, where European judges potentially overrule British courts on matters of citizenship and national security, provide ammunition for that position. If unelected Strasbourg judges can force Britain to accept back some of our own Supreme Court rule to remain stripped of citizenship, what's the point of having British courts and British law? Labour insists they won't leave the ECHR but will seek to reform how it applies. That's having your cake and eating it too. You can't remain bound by a treaty whilst fundamentally disagreeing with how it's interpreted and applied. Either the ECHR's rulings bind Britain or they don't. If they do, and those rulings force outcomes that threaten national security and contradict Supreme Court decisions, then the treaty itself is a problem. Mahmood's willingness to fight this is politically smart and morally right. She's a Labour Home Secretary taking a tough line on national security, defending British sovereignty, and refusing to cave to European pressure.